Good morning. Are you Michaelan Jones? And Mr. Rojas, will your client waive the...
Buckle up, because this is one of those hearings where everything sounds routine, until it's not. We have got a defendant with a list of violations, a judge who does not miss a beat, and a plea deal that's about to unravel a whole lot more than you think.
The formal reading of the motion?
He will, Your Honor.
Mr. Jones, in cause number 22-39715, I have a motion to revoke your...
I'm sorry, just
that's okay.
really want to count 2, 3, and 4 whenever you get to it.
Thank you.
That is correct. Thank you, Mr.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation July 18th of 2022 for the offense of possession of a controlled substance, and that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
And it looks like the agreement is for you to go forward on counts 2, 3, and 4 in that motion. Count 2 alleges that you violated your probation by committing the offense of flight from an officer May 17th of 2023 in parish of Point Coupe in Louisiana. And is that true or not true?
Yes, ma'am.
True or not true?
Now hold up flight from an officer. That's not just running away. In Louisiana, that can rack up serious charges, especially if it involves danger or a vehicle. And yes, you heard right, this guy picked up 3 new charges while already on probation. That's what we call a legal disaster cocktail.
True. Thank you. Count 3 alleges that you committed the offense of illegally carrying of a weapon May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
And then count 4 alleges that you committed the offense of possession of a Schedule I drug on May 17th of 2023, also in the parish of Point Coupe, Louisiana. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, and 4 freely and voluntarily?
Yes, ma'am.
This part might sound like a formality, but it's actually critical. The court has to confirm that the defendant is not being coerced or misled. Because if the plea is not truly voluntary, it could be tossed later and the whole case could spiral back to square one.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 21 months in the state jail prison. You will receive credit on that sentence for any time.
Boom, 21 months in state jail. Let that sink in. What started as deferred probation just turned into prison time. It's a hard reminder when you are on probation. Any new offense is not just a new charge, it's a one-way ticket to revoke your deal and face the original sentence.
That you've been in custody, that the law gives you the right to receive.
The motion was filed in June of 2023 based on offenses that happened in May of 2023. He's been in Louisiana custody since those offense dates of May of 2023. However, our hold for this motion to revoke didn't get placed on him until October 7th of 2024.
And Judge, Mr. Rojas, I'm sorry to interrupt, Mr. Rojas, and I have conferred, the state is not opposed to the court giving the defendant the credit for the time he's been in jail while this case is pending. You may recall, I've researched the issue. I actually briefed it and I gave the court that authority.
You did.
I think you have that authority if you choose to award him that credit.
Okay, so what I'm thinking I would do, I'm not going to go back to the offense date. I think the cleaner way to do it is to go to the date of the motion,
Okay.
which is just a month or so
Right.
or less. But I think that at least for our purposes, if somebody's looking at it, they'll see motion was filed on that date, warrant was issued, but there wasn't a hold place for some reason.
Correct.
And so I'm going to allow credit from June 7th of 2023. In whatever time that adds up to, I will we'll get that.
Okay, courtroom nerds, this part is juicy. The judge is not just rubber stamping the sentence, she's tweaking the jail credit start date. That might sound minor, but it could shave weeks or even months off a sentence. And yes, it's totally legal if justified by custody records and filing dates. Fair, debatable, Legal, yes.
Done, okay?
Thank you, Judge.
All right, so Mr. Jones, I am handing you the trial court certification, well, two things. One, showing that this was an agreement, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir, and thank you, probation, for being here as well. Good morning. Are you Kevin Harmon? And good morning, Ms. Holmes.
Good morning.
Will your client waive the formal reading of the indictment?
Yes.
Mr. Harmon, in cause number 24, DCCR 1612, you are charged with the second-degree felony offense of assault of a peace officer from July 9th of 2024, and how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
Yes, sir.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up.
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Harmon is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. And that'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what's the state's position with regard to bond?
I do have one concern, Your Honor. The call where this happened was a family violence choking incident, where he was charged, I believe, with family violence burglary with intent to commit assault. Those cases we
Whoa, did you catch that curveball? The current charge is assault on a peace officer, but now we are hearing about an unfiled choking case tied to family violence. Even if charges were pursued, the court is hearing about a TAN that could absolutely influence bond decisions or sentencing down the line.
not pursued by the complainant, so they're not pending or anything. But if he gets released, I just want some kind of safeguards in place.
Well, they didn't file the cases, and then I don't know that I can. Where are you going to live when you get out, Mr. Harmon?